Superior Court of the State of California, County of Monterey, Department 17 is now in session. Honorable Judge Julie Culver presiding. Please be seated and come to order. At this time, please silence all cell phones and refrain from talking. Thank you.
Good afternoon and welcome. My name is Julie Culver, as you've heard. I am a judge here in Monterey County, and I'll tell you it's an honor to be here today. This is a courthouse, and actually the very courtroom that I did my first trial as an attorney. So what you're doing today is, for me, kind of going back in history. I'm sure you all are better prepared than I ever could have been. I know you've put hours, weeks, months of effort into this, and it's really an honor to be here. As I say, I'm a judge now. I started out as an attorney before all of you were born, obviously. I was an attorney in the district attorney's office for 14 years. I was then a corporate lawyer for 10 years, and I've been a judge now for almost 10 years. And these are all great jobs. I am, as I say, very honored to be here. I know that this is the pinnacle of mock trial, seeing you all. I know you have been here for several evenings and several days. You've seen a number of different judges. You've got great coaches that have been with you. So a lot of people have participated in getting you here, but you are all the ones that have done the hard work. So I'm anxious to see what you have today. So you have people who are going to be looking closely and watching you, and I'm sure that you will have a lot to show them. So now I'm going to take a few minutes and ask you all to introduce yourselves. So to help myself and the attorney scores, will the prosecution team state your name and your roles and introduce yourselves?
Good afternoon, Your Honor. My name is Tyler Armstrong for the people.
Good afternoon, Your Honor. My name is Miles Prikoski, and along with my co-counsel Nina Franklin,
Good afternoon, Your Honor.
we represent the people of the state of California.
Good afternoon, Your Honor. My name is Sierra Seifert, and I'm Detective Micah Eisenberg.
Good afternoon, Your Honor. My name is Julia Kurz, and I'm Casey Silver.
Good afternoon, Your Honor. My name is Zoe Garderay, and I am Desi Cutstone.
Good afternoon, Your Honor. My name is Grace Dean, and I'm Jules Jackson.
Good afternoon, Your Honor. My name is Juliana Poppy, and I'll be serving as the clerk in today's trial. At this time, may I introduce the timing rules to the court?
Yes.
I'll be giving visual time signals of 2 minutes, 1 minute, 30 seconds, as well as a visual and verbal stop.
Thank you all for being here today. And is the defense team prepared to introduce themselves?
Yes, Your Honor. I am proud to introduce the 2020 Pacific Grove Defense Mock Trial Team. Good afternoon, Your Honor. Juliette Perlstein, Defense Pretrial Attorney.
Good afternoon, Your Honor. Gazelle Ishik, Defense Attorney for my client, Bailey Matsumoto.
Good afternoon, Your Honor. Nor Benny, Defense Attorney for my client, Bailey Matsumoto.
Good afternoon, Your Honor. Lexi Sapiro, Defense Attorney for my client, Bailey Matsumoto. At this time, may our witnesses now introduce themselves?
Yes, thank you.
Good afternoon, Your Honor. My name is Abby Fitzpatrick, and I am Bailey Matsumoto.
Good afternoon, Your Honor. My name is Yume Bishop, and today I am Quinn Flammond.
Good afternoon, Your Honor. My name is Bryce Montgomery, and I'm Dr. Amari Walper.
Good afternoon, Your Honor. My name is Madison Snow, and I am Val Flick. At this time, Mayor Bailey please introduce herself?
Thank you.
Good afternoon, Your Honor. My name is Megan Miller, and I will be serving as your courtroom bailiff for this afternoon's proceedings. At this time, may our unofficial timekeeper please introduce himself?
Good morning, Your Honor. My name is Emmett Withrow, and I will be the unofficial timekeeper for today's proceedings.
So I'm going to provide some instructions at this time, and I'm sure these instructions will be new to you all, so listen very closely. You must complete your presentations within the specified time limits. The clerk will signal you as your time for each section of the presentation begins to run out. When your total time for each section runs out, you will be stopped, even if you have not finished. Attorneys must call for witnesses. This is a bench trial. That means I get to make the decision. At the end of the trial, I will render a verdict of guilty or not guilty in relation to the charge brought. The teams will be rated based on the quality of their presentation, independent of the verdict that I render. Barring unforeseen circumstances, no recesses will be called. If for any reason a recess is necessary, team members should remain in their appropriate places and should have no contact with spectators or coaches. Remember that objections are limited to the California mock trial simplified rules of evidence located in the case packets that I'm sure you all have. And if there are no questions, we will begin with the pretrial arguments. And the motion is being brought by the defense.
Yes, Your Honor. Before the defense proceeds, we have one preliminary matter to address.
Okay.
We've prepared a binder with all relevant case materials and shown it to opposing counsel. Would Your Honor like a copy?
Sure.
May I pass it to the bailiff?
Yes, you can. Thank you.
For reference, we'll be referring to locations depicted in Exhibit A on page 45.
Okay, and the defense has had an opportunity to review the items in this binder, is that correct?
Yes, Your Honor.
So there is a stipulation that the court can receive these?
Yes.
Thank you. Anything further before we get started with the motion?
No, Your Honor. Defense is ready to proceed.
Okay, and this is the defense motion, so you can begin.
My client, Bailey Matsumoto, kept her life private, and for good reason. She wrote a movie script called Roses and Robots in hopes that one day it would be made into a motion picture. She kept the script in her office, where the only two people who were allowed inside were herself and on occasion her cousin Desi Kunstler, who needed to get a key as well as permission from my client. My client had unpatented ideas for autonomous technology and movie scripts and was worried people could steal those ideas if they went rummaging through her office. So she kept her work private. But her movie script, Roses and Robots, was unlawfully taken by Detective Eisenberg in today's case. This was an unlawful search, and my client's Fourth Amendment rights were violated when Detective Eisenberg obtained the script, or Exhibit C, Roses and Robots. Now first, my client never gave Detective Eisenberg permission to search the office. Secondly, Desi Kunstler had no authority to consent to the search of my client's private office. And finally, Detective Eisenberg did not have an objectively reasonable belief that Kunstler could consent.
Well, wasn't Desi living in the same building?
Yes, Your Honor. Kunstler was living in the guest house attached to the office. However, the rooms were completely separated by a door that remained locked all the time. Based on these circumstances, the defense asks that you suppress the script, Roses and Robots, acquired by the unlawful search that Detective Eisenberg conducted. Now first, my client kept the script in her office. She didn't want anybody else going into her office, again because she was afraid that people would steal her ideas. When Detective Eisenberg asked if he could search the mansion, my client specified, "You may search my house and garage," limiting the scope of search. She gave no permission for Detective Eisenberg to search the office or guest house, which is completely detached from the main building.
Well, the person that really was in control of that guest house was Desi, because she was living there.
Yes, Your Honor. Desi Kunstler was a habitant of the guest house, however, not the office connected to it. That office was my client's private office, and it was not a common area.
Okay, you can continue.
Thank you, Your Honor. Now, in the case Katz versus United States, they defined a search as any governmental intrusion upon something a person has a reasonable expectation of privacy. My client had a reasonable expectation of privacy in her private office. She did not want people going inside her office because they could steal her ideas. In fact, her housekeeper of 27 years wasn't even allowed to go in this office. Kunstler only went into the office for purposes of conducting business and no other reason. Bailey Matsumoto had a reasonable expectation of privacy, which was violated when Detective Eisenberg unlawfully searched the office. Secondly, Kunstler could not consent to the search of the office. Kunstler was not an owner or occupant of the office, but rather the guest house attached to it. The office was not a common area, so Kunstler did not have joint access over it. And Bailey Matsumoto was not present at the time Detective Eisenberg asked to search the office. Now, if we look at the case Stoner versus California, a hotel clerk gives consent for officers to search a hotel room of the defendant. However, this consent was not lawful.
So I want to talk about People versus Jenkins, because I really think that's much more similar to this case. Isn't that case one where relative provided some consent for another relative to search something? Isn't that what we have here?
Well, Your Honor, in People versus Jenkins, it was Mrs. Graff who allowed officers to search her bedroom, which she shared with the defendant. That was a common area shared by both the defendant and Mrs. Graff, and it was a bedroom.
It was also a container inside the bedroom.
Yes.
Which would be much more personal than just an office, isn't it?
Yes, Your Honor. It was a bedroom and a container, exactly, making it a lot more personal. So Mrs. Graff could consent to the search because it was a common area and both Mrs. Graff and the defendant had complete and free access over it.
I don't know if I agree with you on that.
Well, the office differs in our case today because Kunstler did not have joint access over the office. It was not a common area. It only had my client's belongings inside of it, and Kunstler only went inside for the purposes of doing work.
I'm just going to go back to Jenkins. Jenkins was a much more private space. That was a bedroom. You're talking about an office. That's not near as private as our bedrooms, is it? I hope not, anyway.
My client still has a reasonable expectation of privacy over her office and the documents within it.
People go into other people's offices all the time.
Yes, Your Honor. However, in this case, it was a governmental intrusion, and Detective Eisenberg did not ask my client specifically if he could enter the office, and that was the consent that he needed in order to carry on with his investigation.
Okay, why don't you continue?
Thank you, Your Honor. Finally, Detective Eisenberg did not have an objectively reasonable basis to believe that Kunstler could consent to the search of the office. He knew that Kunstler was not an owner of the residence, and he also knew Kunstler needed to get a key from my client to get into the office.
But wasn't the door of the office actually open? Isn't that how he got in?
Well, Your Honor, the exterior door was unlocked. However, when Kunstler went in, to our knowledge, he needed to get a key from my client as well as ask for permission. And when Kunstler did enter the office, it was specifically for the purposes of conducting business for my client. Therefore, Kunstler did not have any belongings inside or any documents. In fact, when Detective Eisenberg entered the office, he should have reasonably known that it was my client's office because it was filled with her memorabilia, pictures on the wall of her past entertainment days. At that point, he should have turned around, gone back to ask my client for permission, and then proceed with his investigation.
Okay, thank you.
Finally, my client was in the room over from Kunstler and Detective Eisenberg when Detective Eisenberg asked to search the office. He should have walked over and asked my client to search to further his investigation. In the case Georgia versus Randolph, if two people are physically present and one consents to search but another declines, then the search cannot be conducted. Based on
but Georgia versus Randolph, they were married. This is different. This is just cousins, right?
Yes, Your Honor. I do not believe that the cases are analogous. However, we must look at the court's holding that when two people are physically present and one allows for consent of a search but another does not, it is not lawful to consent.
What about U.S. versus Matlock?
Well, in U.S. versus Matlock, we learned that co-occupants can consent to common areas. That is not analogous to our case today, though, because Desi Kunstler was not a co-occupant of the office area. The office area was not a common area, and Kunstler did not have joint access.
Okay, you can continue.
Based on these circumstances, the defense asks that you suppress the script Roses and Robots, or Exhibit C, from evidence from today's trial. Thank you.
Thank you. And are you ready to proceed with your response?
Yes, Your Honor.
Thank you.
May it please the court. During the course of a homicide investigation at the defendant's home, Detective Micah Eisenberg, a 25-year veteran of the LAPD, searched an office on the premises and found an incriminating movie script. Detective Eisenberg only searched that office after having been granted consent twice. First from the defendant, and then from Desi Kunstler, the defendant's cousin and housemate.
Well, hold on a second. The consent wasn't really given by the defendant to search this office, was it?
Your Honor, Detective Eisenberg had the reasonable belief that that consent had been given.
Oh, okay. Go ahead then, if that's your take on this.
Yes, Your Honor. And because both instances where consent was granted were reasonable, then what we have is a constitutional search, and we ask that you deny the defense's motion. Now, the defense just argued that the defendant never gave consent and that Ms. Kunstler didn't have the authority to do so. Essentially, they argued actual authority. But if we look at the precedent in Illinois v. Rodriguez, we're left with one clear standard: whether or not Detective Eisenberg had a subjective belief of consent and whether that was objectively reasonable.
Well, hold on a second. Wasn't Bailey there? Couldn't detective go and talk to Bailey and get consent directly from her?
Yes, Your
But
Honor.
he didn't do that, did he?
No, Your Honor.
So I'm not quite sure how you're saying Illinois versus Rodriguez applies here.
Because in that moment, Detective Eisenberg believed reasonably that consent had already been given. And based on the facts during Detective Eisenberg's investigation, that was reasonable.
You can continue.
I'd like to start by talking about the defendant's consent specifically. When the defendant gave consent to Detective Eisenberg, she did so in a nonchalant and casual tone. Now, we agree that in a vacuum, those facts would not be enough to meet the Illinois v. Rodriguez standard. But the facts that happened afterward, the actions that followed, made it reasonable. After that, the defendant allowed Detective Eisenberg to wander around the entire property and never once objected to any part of her search.
Well, the rest of the property is kind of common open area. This is an office. This has her private notes. Aren't our notes and our thoughts something that should be more protected than a yard?
Well, absolutely. But if we look at what Detective Eisenberg knew at the time, Detective Eisenberg didn't know what was in that office. So those facts can't factor into Detective Eisenberg's reasonable interpretation.
Okay, you can continue.
Beyond that, Detective Eisenberg ensured that consent was given by everyone on the property. After this, she asked Desi Kunstler for consent as well, and it was granted. But it was reasonable for Detective Eisenberg to rely on that consent. Before this, Detective Eisenberg had interviewed Desi Kunstler. Desi Kunstler made it clear to Detective Eisenberg that she lived on the property. She wasn't just a temporary guest. The other facts in that investigation led Detective Eisenberg to the same conclusion. It was Desi Kunstler who led Detective Eisenberg into the master bathroom, one of the most private areas in an entire home. It was Desi Kunstler who found the body there. After that, when Detective Eisenberg wanted to search the defendant's car, it was Desi Kunstler who handed over the keys. Desi Kunstler, in all of those circumstances, showed some autonomy, some authority in that home.
But Desi Kunstler wasn't the one that had keys to this office. That was only Bailey.
That's correct, Your Honor. But Detective Eisenberg didn't believe those would be necessary, as she had already received consent from two individuals.
You can continue.
When Detective Eisenberg asked Desi Kunstler for consent, counsel brought up the fact that Desi Kunstler had to ask for permission to enter the office of the defendant whenever she wanted to go in. But that's not what the factual record suggests. If we look at our closed library, Desi Kunstler states that when she wanted to go into that office, she usually had to get the key. Not that she always did or always had to ask for permission. She had some authority, and Your Honor, Detective Eisenberg saw that authority.
So isn't this a little bit like Murillo, where there's a couple of keys around, one held by the defendant and one held by someone else?
There's a distinct difference between our case and People v. Murillo. In People v. Murillo, there was no objectively reasonable basis to believe the girlfriend could give consent. In our case, that objectively reasonable basis exists on Ms. Kunstler's part.
Well, I mean, that was a locked briefcase. That's really very private.
Yes, Your Honor.
More private than an office, isn't it?
It's our position that that would be more private than an office, given its circumstances. In our case, we had an unlocked door leading into this office.
Okay, you can continue.
And beyond that, if we look at the case of Stoner v. California, we can see an example of what would have been unreasonable for the police officers to believe. In Stoner v. California, a hotel clerk gave the police consent to search a hotel guest's room.
I'm familiar with Stoner.
Clearly, there's a disconnect between those two parties. Stoner v. California necessitates the importance of roles. But in our case, that clear disconnect just didn't exist. Ms. Kunstler and the defendant are housemates, and their family members. Based on what Detective Eisenberg knew, Desi Kunstler wasn't simply a hotel clerk trying to give away consent without the ability to do so. We don't deny that Detective Eisenberg didn't know all the facts, but the facts that she did know suggested to her that consent could be given and had been given. For that reason, we ask that you deny the defense's motion. Thank you.
Thank you. And rebuttal?
Yes, Your Honor. Your Honor, opposing counsel states that Detective Eisenberg didn't know what was inside of the office. But when he entered that office, a reasonable person would have known that all of the memorabilia inside, all of the pictures, all of the movie scripts belonged to my client. There was not a single thing in that office that belonged to Desi Kunstler. Now, the prosecution also used Stoner versus California, but that case is extremely comparative to our case today. Kunstler is almost exactly like the hotel clerk. They both were doing their jobs. The clerk went into the room to do their job, and they needed to get permission to do so. Kunstler only went into the office to do her job for my client. The clerk had no belongings inside of a random hotel room, and Desi Kunstler had no belongings inside of my client's private office. Now, opposing counsel also used the case Illinois versus Rodriguez, stating that, that police officers, if they had a reasonable belief that then consent over a common area is lawful. But we have to look at the facts of today's case. It was not a common area shared by both the defendant and Kunstler. A common area is somewhere in which multiple people have multiple uses over. Kunstler does have common areas throughout the mansion, in the laundry room, the kitchen, the living room, etc. However, my client's private office is not under those specifications.
I really don't agree that an office that is that private, when you allow people to go in there on a regular basis to go through your things. I mean, that certainly qualifies as a common area, doesn't it?
Well, we have to look at the reasoning that Kunstler went in there.
Well, I want to just talk about, it's not like the police are going into some locked briefcase or a locked item inside. This is a room that was unlocked, that they were able to get access to, that the defendant allowed other people to go into on a regular basis. I don't see the difference.
Well, Your Honor, that doesn't mean my client doesn't have a reasonable expectation of privacy. If we look at a car...
Well, it's not her reasonable expectation. It's, in general, should someone, not her in particular.
Yes, Your Honor. But if we look at an analogy, for example, if there was a parked car and somebody forgot to lock it, that doesn't mean that a person's reasonable expectation of privacy is eliminated and officers search it. My client is very similar. Just because she accidentally left an exterior door unlocked doesn't mean that she wants anybody and everybody to enter her office and look through her personal belongings.
Well, wouldn't you agree that an office is less private than someone's bedroom?
Yes, Your Honor.
And an office isn't, I don't know, I'm just failing to see why I should be so concerned about someone's office. I let people in and out of my office all the time.
Well, Your Honor, her office had unpatented ideas for autonomous technology as well as movie scripts.
I keep private notes in my office too. People would be surprised, I'm sure.
Yes, Your Honor. However, my client was very protective of her belongings, and she had a reasonable expectation of privacy of her office and the documents inside of it.
How are the police supposed to know that?
Well, Your Honor, the police should have asked my client for consent before entering her private office. All that Detective Eisenberg knew was that this was my client's mansion, and Desi Kunstler was a habitant inside the guest house. But in order to get into the office, even Kunstler stated he needed to get a key from my client. Therefore, this is my client's personal office, completely private, with her belongings specifically. And therefore, nobody else, especially Detective Eisenberg, should have been allowed to go and search the office without specific consent given from my client.
Okay.
Your Honor, based on these circumstances, the defense asks that you suppress the evidence of roses and robots, as well as, the same as Exhibit C, and from today's trial. Thank you.
Thank you. And the people?
Yes, Your Honor. May I proceed?
Yes.
During counsel's rebuttal, Your Honor discussed a reasonable expectation of privacy, so I'd like to delve further into that. For an example of a reasonable expectation of privacy, we have Cats. In Cats, it was a phone booth. No one knew what was said in there, no one knew what was going on. That was undeniably private. In our case, we have an office...
Cats was undeniably private? That's a phone booth in a public spot.
Yes, Your Honor, but no one could listen in on what the defendant was saying. Nobody knew what business was being conducted.
I was about to ask you if you know what a phone booth is. Go ahead.
Your Honor, what we have in this case, we have an unlocked office in which Desi Kunstler went in periodically to take items in and out. Now, counsel also referred to the fact that the office was filled with the defendant's personal belongings. But Your Honor, not only was that unclear to Detective Eisenberg, but Detective Eisenberg had no knowledge of that in the first place. Even once inside that office, there could be various items within an office that are not attributable to a single person. So Your Honor, those facts were not enough to dissuade Detective Eisenberg in this case. And counsel also referred to the working relationship between Desi Kunstler and the defendant. The detective was never made aware of that either. When we look at what Detective Eisenberg knew about that office, she didn't know whose office it was. She didn't know who goes in it. She didn't know how frequently people go in it. Detective Eisenberg only knew that she had received consent, that Desi Kunstler lived on that property, and that Desi Kunstler had some authority.
So you will agree, though, that the detective had access to the person who had the key and whose office this was?
Yes, Your Honor, we do agree with you.
Okay.
But even with those facts, even with Detective Eisenberg knowing where the key was, there was an unlocked door. That key was not necessary. And for Detective Eisenberg, her actions were reasonable. Based on that, Illinois v. Rodriguez tells us that what we have is a constitutional search. So for that reason, we ask that you deny the defense's motion. Thank you.
Thank you. And before I rule on the motion, students may confer with their attorney-teacher coaches regarding any trial or hearing irregularities. Would either of you like to consult with your coaches?
No, Your Honor.
Not necessary from the defense, Your Honor.
Thank you. And I am going to rule on the motion. I think that the motion has been well presented by both sides. It's very clear that you are both well aware of the facts that are involved in this case and are able to understand the law that applies to this case. I am very used to one side winning and one side losing, and I realize that I always, they say, make a friend for a short period of time and an enemy forever, and I'm ready to do that. So at this time, I'll respectfully deny the motion to suppress. The document and the item of evidence will be allowed to be used at trial.
Yes, Your Honor. Permission to rearrange?
Yes.
Thank you, Your Honor.
So is there physical evidence that you need to exchange, or has that been handled already?
Yes, Your Honor, we've prepared exhibit binders with all 5 relevant exhibits. The exhibit binder has already been shown to opposing counsel. May I hand a copy to the bailiff to put one on the stand?
Yes. And defense counsel has already looked at the exhibit binder and is stipulating to the items that are in that?
Yes, Your Honor.
Okay, thank you. So this is a criminal case that we're handling today, and the criminal case is the people of the state of California versus Bailey Matsumoto. The people of the state of California are charging the defendant, Bailey Matsumoto, with murder, which is the unlawful killing of another human being with malice aforethought. Prosecution, are you ready to begin with your opening statements?
Before we begin with our opening statement, we do have a few preliminary matters to address.
Okay.
We just wanted to clarify first things first that we've updated the information in errata to charge the defendant with not just murder and malice aforethought, but Section 189, murder in the first degree.
Yes, I'm sorry that I did not note that. Thank you for bringing that to the court's attention.
We also want to clarify as to your preferences for moving about the courtroom and approaching witnesses during the trial.
So my rules in court are always that to enter the well, you do need permission.
Yes, Your Honor.
And approaching the witness is the same.
Absolutely, Your Honor. Finally, we want to remind the court of Stipulation 17, which states that the decedent in today's case, Taylor Matsumoto, is to be referred to as using the pronouns they or them rather than the pronouns he or she.
Thank you.
And with that, we're ready to proceed.
Okay. Anything that needs to be handled on behalf of the defense?
Nothing from the defense, Your Honor.
Thank you. So with that, are the people ready to proceed with their opening statement?
Yes, Your Honor. May it please the court? The defendant, Bailey Matsumoto, had a problem. You see, Bailey Matsumoto had invested all of her savings into a company that produced autonomous vehicles. But her spouse, Taylor, was advocating fiercely against the use of autonomous technology. Things came to a head between the two on June 7th of 2019. Taylor told the defendant about their plans of testifying on Capitol Hill in favor of a national ban on autonomous technology. Your Honor, if Taylor were to be successful, the defendant would lose everything. So, the defendant came up with a plan. Kill Taylor and make it look like an accident. That night, she prepared a rose petal bath for Taylor, and when Taylor came home drunk, she struck them on the back of their head with a golf club, causing them to fall unconscious into a bathtub and drown. Your Honor, it all went according to plan. Now, because of this, the people have charged the defendant in violation of California Penal Code Section 189. To meet our burden, we must prove to you beyond a reasonable doubt that the defendant killed Taylor and that she did so willfully, deliberately, and with premeditation. We will be able to meet that burden. You're going to hear from Detective Micah Eisenberg. She was the lead detective in today's case, and she's going to explain to you how the golf club she found in the back seat of the defendant's car matches the wound found on the back of Taylor Matsumoto's head. Casey Silver is going to be the next to take the stand. She was a friend of Taylor Matsumoto, and she's going to tell the court about Taylor's plans of testifying on Capitol Hill. She'll tell the court how Taylor never got to do that. Desi Kunstler, the defendant's own cousin, will be the next to testify. Your Honor, she was there in the defendant's home on the night of June 7th. She'll tell you she heard the two arguing. And shortly after, at 11:20 p.m., she heard the sound of something breaking. Your Honor, the evidence today will show that what Miss Kunstler heard was the defendant killing Taylor Matsumoto. Dr. Jules Jackson, the medical examiner in today's case, will be the last to testify. She's going to explain to the court the connection between the golf club found in the back of the defendant's car to the wound on the back of Taylor Matsumoto's head. And how absent that wound, Taylor Matsumoto would be alive today. Your Honor, Taylor Matsumoto threatened the defendant's business. So she silenced them. It all went according to plan. At the end of today's trial, we're going to ask that you find the defendant guilty as charged. Thank you.
And would the defense like to do their opening now or reserve?
Now, Your Honor.
Thank you.
Bailey and Taylor Matsumoto lived in a beautiful house had a perfect relationship, and even recently founded a startup for self-driving vehicles. But tragedy struck, and their picture-perfect family fell apart. Bailey, a sci-fi director, and Taylor, a technical advisor, met in the entertainment industry, where their shared passion for the future led them to found a startup for new technology, specifically autonomous vehicles. Taylor and their son Michael, who you will hear Bailey loved as one of her own, moved in with Bailey. But tragedy struck when Michael died while riding one of the company's very own autonomous scooters. Taylor fell into a severe depression and was quick to blame Michael's death on the startup. After this tragedy, Miss Matsumoto was there to support Taylor. She even made an effort to remember Michael by preparing a shadow box with Michael's favorite putter. And Your Honor, the night of June 7th was no different. On the night of June 7th, Miss Matsumoto prepared a bath with roses and champagne for Taylor. But, as was too often the case, Taylor came home drunk that night. And during an argument, the champagne bottle broke, and Miss Matsumoto left Taylor alone. Alone in the wet bathroom, Taylor accidentally slipped and fell, leading to her tragic death. And you will hear that Bailey did not kill Taylor. You will also hear from Quinn Clampett, the Matsumoto housekeeper, who will testify to the smooth and slippery floor in the bathroom, and will testify that even she herself has slipped and injured herself in this same bathroom. You will also hear from Dr. Amari Wolpert, who will testify to the manner of death and will explain that his conclusion directly conflicts with that of the medical examiner. And lastly, Val Glick will corroborate that the golf club was being prepared as a memento and not as a murder weapon. The prosecution's alleged cause of injury was in fact a keepsake. And after reviewing all of the evidence in today's case, you will see that the people's case is filled with reasonable doubt. And you will see that the people's case relies on unreasonable conclusions from the evidence. And we will ask you from preventing another tragedy from happening and finding Bailey Matsumoto not guilty. Thank you.
Thank you. And is the prosecution ready with their first witness?
Yes, Your Honor. The people call Micah Eisenberg to the stand.
Calling Detective Micah Eisenberg. Please follow me. Please raise your right hands. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? I do. Please be seated. Please state your full name, spelling your last for the record.
Micah Eisenberg, E-I-S-E-N-B-E-R-G.
Thank you. You may proceed.
Good afternoon, Detective.
Good afternoon, ma'am.
What do you do for a living?
I'm a detective for the Los Angeles Police Department.
And how long have you been a detective for the LAPD?
13 years now.
What's your involvement in today's case?
Oh, ma'am, I was the first on scene and the lead investigator in today's case.
Detective, what's the first thing that you did after arriving on scene?
I immediately made contact with Bailey Matsumoto, who I subsequently learned was the owner of the property.
Do you see Bailey Matsumoto in court today?
I do, ma'am.
Could you please identify her by an article of clothing?
Absolutely. She's sitting at the end of counsel's table wearing a green blouse and black jacket.
Indicating the defendant for the record.
Now, what's the next thing you did after making contact with the defendant?
I proceeded through the garage of the residence to the master bathroom where the body had been found.
Did you see anything on your way through the garage?
I did, ma'am. An autonomous vehicle in the garage caught my attention, and I noticed a golf club in the back seat.
Now, did you find anything once you got to the master bathroom?
I did. There was a body floating face up in a bathtub, which was full of water and rose petals.
Please refer to what's been marked for identification as Exhibit B in the binder in front of you.
Of course.
Do you recognize this?
I do, ma'am.
What is it?
This is a diagram that I prepared of the Matsumoto master bathroom.
And does it fairly and accurately depict the defendant's master bathroom as you saw it on the morning of June 8th, 2019?
It does, ma'am.
The people move Exhibit B into evidence.
Any objection?
No, Your Honor.
It will be received.
Now, Detective, what did you do after locating a body inside the bathroom?
I confirmed that the individual was deceased, and then I performed a quick examination on the body.
Did you find anything?
I did, ma'am. I noticed a 4 by 1.5 inch contusion on the back of the decedent's head.
Now, what did you decide to do next in your investigation?
I then secured the home and I returned back to the garage.
Why did you choose to go back to the garage?
Because of the golf club that I mentioned seeing earlier. It seemed out of place and I wanted to examine it further.
Were you able to examine it?
I was, ma'am.
Please refer to what's been marked for identification as Exhibit D in the binder. Do you recognize this?
I do, ma'am.
What is it?
This is a photograph of the golf club that I seized from the defendant's vehicle.
Does it fairly and accurately depict the golf club you seized?
It does.
The people move Exhibit D into evidence.
Any objection?
No, Your Honor.
Will be received.
Now, you said you examined this club. Did you find anything?
I did, ma'am. It smelled of bleach.
Detective, did you ever interview the defendant about the scene that you found in the master bathroom?
I did, ma'am. The defendant confirmed having drawn a rose petal bath and having been present in the master bathroom with Taylor Matsumoto at around 11:20 on the night of June 7th.
Now, did you do any further investigation of the defendant's property?
I did, ma'am. I requested and received consent to search an office on the premises, so I proceeded to do so.
Did you find anything?
I did, ma'am. I seized a movie script in that office.
Why do you choose to seize a movie script?
The content of that script bore some similarities to the scene of Taylor Matsumoto's death.
Please refer to what's been marked for identification as Exhibit C in front of you. Do you recognize this?
I do, ma'am.
What is it?
This is a copy of the script that I seized.
Does it fairly and accurately depict the script you seized?
It does.
The people move Exhibit C into evidence.
Any objection?
Yes, Your Honor, as the script is more prejudicial than probative.
Response?
Your Honor, this script goes directly to the defendant's premeditation. Inside this script, it's a rose petal bath in which someone is murdered inside that bath, and that murder is made to look like an accident. This is highly probative in today's case. And as to the prejudicial value, this is a bench trial, Your Honor. You've already seen this exhibit as you ruled on it in the pretrial motion, so we don't believe this would unfairly prejudice Your Honor.
The objection will be overruled. Really, any evidence, most evidence that's being entered by the prosecution is going to be prejudicial. I don't find, when I say prejudicial, I mean that it's, I presume, will head towards guilt. I don't find that it's unduly prejudicial. So you can, it will be received. That objection is overruled.
Thank you, Your Honor.
Now, Detective, you mentioned that there were some similarities between what you saw in the script and what you saw inside the defendant's master bathroom. Could you please tell the court what those similarities were?
No, of course. Both involved alcohol, a rose petal bath, and a drowning.
Who authored that script, Detective?
The defendant.
Thank you, Detective. Nothing further at this time, Your Honor.
Cross-examination?
Yes, Your Honor. Good afternoon, Detective.
Good afternoon, ma'am.
You arrived at the Matsumoto residence on June 8th at 7:55 a.m., right?
That's right.
And when you arrived at the mansion, you entered the garage, correct?
I did, ma'am.
And in the garage, you observed a golf club in the back of Miss Matsumoto's vehicle, correct?
That's right. It was an autonomous vehicle.
And when you asked Miss Matsumoto where the keys to the car were, she didn't know where they were, right?
Right.
Objection, speculation.
Response?
Your Honor, this detective has asked Miss Matsumoto where the keys to the car were, and when she did not know where to locate them, she had knowledge that Miss Matsumoto didn't know where the keys to the car were.
May I be heard, Your Honor?
No, I'm going to rule it this time. Overruled. You can continue.
Thank you, Your Honor. Did you get a chance to answer my question?
I did, ma'am. I said that the defendant didn't know where they were, however, Desi Kunstler provided them to me.
And while you were at the mansion, you also investigated the master bathroom, right?
I did.
And you noticed that the bathroom had a marble floor?
That's right, ma'am.
And you noticed that the bathroom was at ground level?
It was.
And you also observed Taylor Matsumoto's fully clothed body in the bathtub, right?
I did.
And while you were in the bathroom, you took detailed dimensions of the trough, right?
I did, and I provided them in my diagram.
Right. And you noticed that the trough has two edges that are each 1 inch wide?
It does, ma'am.
And you also took detailed dimensions of the trough, isn't that correct?
That's right.
I'm sorry, the golf club?
I did, and I provided that in another exhibit.
And you noticed that the golf club has a face height of 1 inch?
It does.
But at first, you only presented Dr. Jackson with physical evidence of the golf club as the possible cause of injury, right?
I did, ma'am, because it matched the dimensions of the wound.
Thank you, Your Honor. No further questions.
Any redirect?
Yes, Your Honor. Counsel asked you a few questions about the dimensions of the trough in this case versus the dimensions of the golf club. What were the dimensions of the trough?
The trough was 1 inch wide, however, it was 20 inches long.
What were the dimensions of the golf club?
The golf club was 4 inches by 1 inch wide.
And what were the dimensions of the wound you found on the back of Taylor Matsumoto's head?
The wound was 4 inches long and 1.5 inches wide.
Thank you, Detective. Nothing further, Your Honor. May the detective be excused. Recross is not permitted, Your Honor.
Thank you. Yes, she can be.
And at this time, the people call Casey Silver to the stand.
Calling Casey Silver. Please follow me. Please raise your right hands. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? I do. Please be seated. Please state your full name, spelling your last for the record.
Casey Silber, Silber.
May I proceed?
Yes.
Good afternoon, Miss Silver.
Good afternoon.
What do you do for a living?
I'm a member of an organization called PAD. We lobby against the use of autonomous vehicles.
What does PAD stand for?
Parents Against Autonomous Driving.
Now, Miss Silver, did you know Taylor Matsumoto?
Yes. We were the best of friends, and we met through PAD.
How would you describe Taylor's involvement in PAD?
Taylor founded it. Taylor was one of our most vocal members.
What makes you say that?
Taylor was planning to testify on Capitol Hill in favor of a bill that would ban the use of autonomous vehicles.
Did Taylor get to testify?
No. Taylor died just a few days beforehand.
I'd now like to turn your attention to Bailey Matsumoto. Do you know the defendant?
Yes, I know Bailey.
Have you ever spoken with the defendant?
I avoided Bailey as much as possible. There was one time that I do remember, though.
Could you please describe this instance to the court?
Of course. Last May, I was at a restaurant, and Bailey was there, and Bailey approached me and asked, "Why did you turn Taylor against me? I married Taylor for the success of this startup."
Do you know what startup the defendant was referring to?
Bailey has a business designing autonomous vehicles.
Now, you mentioned earlier that Taylor had plans of testifying on Capitol Hill. Did you ever discuss this with Taylor?
Yes, we did.
When?
On the evening of June 7th, when I went to pick Taylor up to take them to a PAD meeting.
How did Taylor appear when you picked them up?
Taylor looked extremely upset.
Did Taylor say why?
Yes. Taylor told me that Taylor and Bailey had been fighting because Bailey did not want Taylor to go to Capitol Hill.
Objection, Your Honor. Hearsay.
Your response?
Your Honor, this falls under the hearsay exception, excited utterance. We've laid the foundation that Taylor Matsumoto was under the stress of this incident. Taylor appeared upset when going in with Miss Silver, and this is her statement describing the incident that occurred.
I'll allow further response.
Your Honor, an argument does not stand as a dramatic experience that would cause an excited utterance.
I would tend to agree. I'm going to...
May I be heard?
Yes.
The excited utterance rule specifically states that a statement that describes or explains an event perceived by the declarant made during or shortly after a startling event. An argument is surely a startling event as things get heated between the two, and this is, we've laid the foundation that Taylor Matsumoto was under the stress of this event.
I don't find the stress being sufficient for the exception. So it's sustained. You can move on.
Your Honor, move to strike.
Motion to strike is granted.
Thank you, Your Honor.
When was the last time that you saw Taylor?
When I dropped Taylor off at the mansion later that night.
Thank you, Ms. Silber. Nothing further at this time, Your Honor.
Thank you. Cross-examination?
Yes, Your Honor. Good afternoon, Ms. Silber.
Good afternoon.
On the night of June 7th, you went to an event with Taylor, correct?
A pad meeting, yes.
And at this fundraiser, you didn't see Taylor eating anything, did you?
Objection, relevance.
Is there any relevance?
Yes, Your Honor. As to Taylor, if Taylor had not eaten anything, then the effects of the alcohol would be more dramatic.
I'll overrule.
Your Honor, may be heard.
Okay.
The parties have already stipulated that Taylor Matsumoto had a blood alcohol content of 0.12. We've stipulated that Taylor Matsumoto was under the influence of alcohol. We believe that
under those circumstances, it will be does not appear to be relevant.
May I be heard?
Okay.
Your Honor, as to the 0.12, nobody knows what a level of 0.12 of alcohol would cause on a single person, and it is reasonable to think that if someone had not eaten anything, that the alcohol level would cause even more of a disturbance to that.
You know what? I think we'll leave that to the expert, so the objection is sustained.
Move to strike if an answer was given.
And the answer will be stricken. Go ahead.
But you did see Taylor drinking alcohol, correct?
Yes, at the meeting I saw Taylor have a couple vodka sodas.
And when you dropped Taylor back off at the mansion, they were clearly drunk, right?
Yes, yes.
But that's not what you told Detective Eisenberg, was it?
I told Detective Eisenberg that Taylor was tipsy.
But you did observe a clearly drunk Taylor, right?
Yes, that's true.
And didn't it upset you that Bailey would often argue with your friend Taylor?
I guess I was concerned about Taylor. I'm not quite sure I understand your question.
Didn't it upset you that Bailey would often argue in heated discussions with your friend Taylor?
I suppose, yes. I think Taylor was stressed.
And didn't it upset you that Bailey ran an autonomous driving company?
I did not support Bailey's business, no.
So is that a yes to my question?
Yes, that I did not support Bailey's business.
Thank you, Your Honor. No further questions.
No redirect, Your Honor. May Ms. Silver be excused?
Thank you. You are excused. People's next witness?
Before we call our next witness, may I ask for a time check as for closings and directs?
Yes.
For closing arguments, the prosecution has 5 minutes and 18 seconds, and the defense has 6 minutes and 27 seconds. For direct, prosecution has 6 minutes and 17 seconds, and for cross, the defense has 6 minutes and 53 seconds.
Thank you.
Thank you.
Your next witness?
With that, the people call Desi Kunstler to the stand.
Calling Desi Kunstler. Please follow me. Please raise your right hands. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. Please state your full name, spelling your last for the record.
Desi Kunstler, Kunstler.
Good afternoon. Your
May I
witness?
proceed?
Yes.
Good afternoon, Ms. Kunstler.
Good afternoon.
What do you do for a living?
I'm currently between jobs.
Do you know Bailey Matsumoto?
Yes, she's my cousin. I've been living with her recently.
Were you at home on June 7th of 2019?
Yes, I was home with Bailey and her spouse, Taylor.
I want to talk to you a little bit about that day. During the afternoon, did you ever see the defendant and her spouse interact with each other?
I did. They had an argument in the afternoon.
Do you remember what was said?
Yes. Taylor muttered something about divorce and said, "Your robot scooter killed my son."
Objection, Your Honor. Hearsay.
Your response?
Your Honor, we're not using these statements for the truth of the matter. We don't actually want to prove that a scooter killed Taylor Matsumoto's late son. Rather, we're using them to show the effect on the listener.
Anything further? I will allow it for that limited purpose. You can go ahead.
Thank you, Your Honor.
Ms. Kunstler, I want to fast forward to later that evening. Were you home then?
I was.
Was Taylor home?
No, Taylor got home around 11 p.m.
What'd you do after Taylor got home?
I went to do my laundry.
Turning your attention to what's been marked for identification as Exhibit A in the binder in front of you. Do you recognize Exhibit A, Ms. Kunstler?
I do.
What is it?
This is a diagram of Bailey's mansion.
And is that a fair and accurate depiction in front of you of what Bailey's mansion looks like on the night of June 7th?
It is.
The people offer Exhibit A into evidence.
Any objection?
None, Your Honor.
It will be received.
Ms. Kunstler, using Exhibit A, could you show the court where the laundry room is?
Of course. The laundry room is right here, adjacent to the master bathroom.
Thank you.
May the record reflect that the witnesses gestured to the exhibit?
Yes.
Ms. Kunstler, what happened while you were doing laundry?
I heard Taylor shouting from the direction of the master bathroom.
Did you hear anything that Taylor said?
Yes. Taylor shouted something about testifying, and then there was the sound of something breaking.
Objection, Your Honor. Hearsay as to Taylor shouting something about testifying.
Response?
Again, Your Honor, the statement's not being used for the truth, rather to show the effect on the listener. The statement about testifying leads to that loud crash.
Anything further?
No, Your Honor.
Okay, it will be allowed for that limited purpose, not for the truth of the matter.
Ms. Kunstler, I'll ask the question again.
I think we've already heard it.
Yes, Your Honor. What'd you do after you heard that sound?
I called out, asking if everything was okay.
And did you get a response?
Yes. Bailey said, "We're okay. We're going back to bed now."
Ms. Kunstler, did Taylor respond?
No.
There's been testimony that Taylor was set to testify on Capitol Hill in favor of a national ban on autonomous vehicles only days after she was found dead. Do you know if the defendant ever said anything about that testimony?
Yes. She muttered something about it a few hours after their fight in the afternoon.
Can you tell the court what she said?
Wouldn't it be too bad if Taylor didn't make it to the Capitol Hill hearing?
Thank you, Ms. Kunstler. Thank you, Your Honor. No further questions at this time.
Cross-examination?
Yes, Your Honor. Good afternoon, Ms. Kunstler.
Good afternoon.
At first, Taylor and Bailey Matsumoto had a pretty good relationship, right?
Yes.
But you didn't have a very good relationship with my client?
Bailey and I haven't always seen eye to eye.
You even went on to call her spoiled and selfish, right?
Bailey can be spoiled and selfish, yes.
And isn't it true that my client pestered you to move out of her house?
She did.
And my client is your only living relative, isn't that true?
That's correct.
And isn't it true that my client received a large inheritance from your family?
Objection, Your Honor. Irrelevance as to the inheritance.
Your response?
Your Honor, this goes to bias because this witness could have inherited this large property. However, this property went to Miss Matsumoto.
Okay, anything further?
Submitted for ruling, Your Honor.
Overruled.
Thank you, Your Honor. Did you get a chance to answer my question?
Could you repeat the question?
Isn't it true that my client received a large inheritance from your family?
Yes, from our wealthiest relative.
And on June 7th, around 9:35 p.m., Taylor sent you a text. Isn't that true?
Yes, that's correct.
And you knew from the text that Taylor was drunk, right?
Yes, there were a few typos in the text message.
And around 11 p.m., you observed Taylor to be drunk, right?
Taylor came home and they were stumbling.
Is that a yes?
Yes, they seem drunk.
And around 11:20 p.m., you heard a loud crash, right?
Yes, at this time I was in the laundry room.
But immediately after this crash, did you hear a splash?
I don't recall hearing a splash.
Thank you, Your Honor. No further questions.
May redirect?
No redirect examination, Your Honor. May this witness be excused?
Yes.
May the people call our next witness?
Yes.
May the people call Dr. Jules Jackson to the stand.
Calling Dr. Jules Jackson. Please follow me. Please raise your right hands. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. Please state your full name, spelling your last for the record.
Jules Jackson, Jackson.
Thank you. Your witness?
Good afternoon, Dr. Jackson.
Good afternoon.
What do you do for a living?
I'm the Chief Medical Examiner for LA County.
How long have you held that position?
Since 2005, 15 years.
What are your qualifications as the Chief Medical Examiner?
I received my training from UCLA, and I've also done various residencies and fellowships in my field.
So, how were you involved in today's case, Doctor?
I was called to the scene of the Matsumoto residence on June 8th, 2019 by Detective Eisenberg. I completed a postmortem examination of Taylor Matsumoto's body that same day.
Were you able to come to a conclusion as to the cause of death for Taylor Matsumoto?
I was. Taylor Matsumoto died by drowning, secondary to blunt force trauma to the back of the head.
Dr. Jackson, were you also able to come to a conclusion as to time of death for Taylor?
Yes, I was.
How so?
I performed a lividity analysis.
Could you explain to the court what lividity means?
Of course. When a person goes into cardiac arrest, their blood stops circulating and then coagulates. The time it takes to do so can be used to determine the time of death.
So, what did your lividity test reveal?
Taylor Matsumoto died between 10 p.m. and midnight on the night of June 7th, 2019.
You also mentioned conducting a post-mortem examination. What did you learn from that?
Taylor Matsumoto suffered blunt force trauma to the back of the head at the parietal bone. I found a depressed skull fracture and a contusion at that location.
And turning your attention to what's been marked for identification as Exhibit E in the binder in front of you. Do you recognize Exhibit E, Doctor?
I do. This is a diagram I prepared of Taylor Matsumoto's head injury.
And is that a fair and accurate diagram of what Taylor's head injury looked like the morning of June 8th?
It is.
The people offer Exhibit E into evidence.
Any objection?
None, Your Honor.
It will be received.
Dr. Jackson, did Detective Eisenberg ever ask you to match a source to what you diagrammed?
Yes, she asked me to examine a golf club.
Turning your attention to what's been marked, admitted into evidence as Exhibit D. Do you recognize this, Doctor?
Yes, this is the golf club that Detective Eisenberg gave me.
And were you able to come to a conclusion as to whether that golf club could have caused the contusion on the back of Taylor's head?
Yes, it certainly could have.
What led you to that conclusion?
Taylor Matsumoto had a depressed skull fracture. This indicates a direct blow to the back of the head from a blunt instrument, not a fall.
Is there anything else that led you to that conclusion?
The dimensions of the wound in the golf club are consistent.
You mentioned that Taylor died by drowning secondary to blunt force trauma. What do you mean by that?
The blunt force trauma likely knocked Taylor unconscious and face first into the bathtub where Taylor drowned. But absent the blunt force trauma, Taylor Matsumoto would still be alive.
Thank you, Dr. Jackson. Thank you, Your Honor. No further questions at this time.
Thank you. Cross-examination?
Yes, Your Honor. Good afternoon, Dr. Jackson.
Good afternoon, ma'am.
On June 8th, you arrived in the master bathroom, correct?
Yes, at 8:30 at the Matsumoto residence.
And you saw Taylor Matsumoto's body inside the bathtub, is that correct?
That's right, ma'am.
Now, you believe that the golf club caused the contusion on the back of Taylor's head.
Yes, for a couple of reasons.
And you are aware that Detective Eisenberg provided you with detailed sketches of this same master bathroom?
Yes, that's right.
However, you never reviewed these sketches in your investigation, did you?
No, I did. I'm familiar with the dimensions of the master bathroom.
However, you never included them in your report, did you?
No, I didn't.
You never mentioned anything about the dimensions of the bathroom, did you?
No, but I learned about them from Dr. Wolpert's report, as well as what Detective Eisenberg told me.
However, that was after you made your report, is that correct?
No.
You reviewed Dr. Wolpert's report after you made your report, correct?
No.
So you made your findings and conclusions about the manner of Taylor's death after Dr. Wolpert made his conclusions.
I'm sorry, ma'am, I was confused the first time. That's correct.
Now, the golf club was the only object that you examined, correct?
Yes, that's right. But again, I'm familiar with the dimensions in the master bathroom.
Now, you are aware that the master bathroom has a marble floor, is that correct?
Yes, that's right.
And you're aware that this marble floor can make it easy for someone to possibly slip, correct?
I suppose so.
Especially if that person was drunk?
Sure.
Now, a toxicology report stated that Taylor Matsumoto had a blood alcohol content of 0.12.
Yes, that's right.
Generally, this would cause loss of judgment and maybe loss of motor controls, correct?
Slurring of words, loss of judgment, but it's never fatal.
But you would agree that this would cause impairment?
It could.
Now, you state the time of death to be between 10 p.m. on June 7th and 12 a.m. on June 8th, is that correct?
Yes.
You also analyzed the rigor mortis of Taylor Matsumoto's body.
I did, but I didn't find it helpful in reaching my conclusion as to the time of death.
Now, rigor mortis completely stiffens the body 12 hours after death, is that correct?
Yes, but it's a range of time. It's from 8 to 12.
But it starts to stiffen the body 3 to 4 hours after death, is that correct?
Yes.
Now, you conducted Taylor Matsumoto's autopsy at 10 a.m., is that correct?
Yes, after I first examined the body at 8:30.
And at 10 a.m., Taylor Matsumoto's body was still movable.
As was it at 8:30.
And that meant that rigor mortis had not completely set in, is that correct?
Not necessarily, counsel. I found the use of rigor mortis inaccurate in today's case, given that the body was found in a bathtub.
But previously, you stated that rigor mortis completely stiffens the body at 12 hours, correct?
Objection, Your Honor, asked and answered.
No, I think as phrased, it's a little bit different. You can answer.
Is that correct?
Again, counsel, it is a range of time, from 8 to 12 hours.
So, because the body was still movable at 10, rigor mortis had not completely stiffened the body, correct?
Yes, but again, I find the use of rigor mortis in today's case inaccurate.
So, according to the rigor mortis of Taylor Matsumoto's body, they could have died between 10 p.m. on June 7th and 4 a.m. on June 8th, correct?
Yes, using that particular method.
Now, isn't it true that it is very difficult to match blunt force objects to contusions?
It can be, yes.
Thank you, Dr. Jackson. Thank you, Your Honor. No further questions.
Thank you. Any redirect?
No redirect, Your Honor. May this witness be excused?
Yes. Thank you.
And with that, the people rest.
Thank you. And is the defense ready with their case?
Yes, Your Honor. The
You can call your
defense,
first witness.
the defense calls Bailey Matsumoto to the witness stand.
Calling Bailey Matsumoto. Please follow me. Please raise your right hands. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. Please state your full name, spelling your last for the record.
Bailey Matsumoto, Matsumoto.
Thank you. Your witness?
Good afternoon, Ms. Matsumoto.
Good afternoon.
What do you do for a living?
I'm a former movie producer and scriptwriter, but now I spend most of my time in Taylor and I's autonomous driving startup.
And who was Taylor?
Taylor was my spouse.
Did anything happen to Taylor?
Yes, Taylor died in a tragic accident last June.
Objection, speculation.
Overruled at this time.
Did you and Taylor have any kids?
Yes, Taylor had a son named Michael who became like my own.
Did anything happen to Michael?
Yes, Michael died when one of our autonomous scooters malfunctioned after I left it unlocked, and Michael died, which I take responsibility for.
Now, after Michael's death, did you notice a change in Taylor's behavior?
Yes, I definitely did. Taylor and I were both devastated with the loss of Michael.
Did Taylor take any action?
Yes, Taylor formed Parents Against Autonomous Driving to cope.
And did this have an effect on your relationship?
Yes, definitely had an effect on our relationship. Taylor was the brains behind our company, and investors also threatened to pull out.
Did this have an effect on your business?
Yes, definitely did.
Now, on June 7th, did you talk with Taylor?
Yes, we had an argument.
What was that argument about?
The argument was about upcoming events, our meeting in Los Angeles about our company with investors, and Taylor wanting to testify in Washington, D.C. against autonomous technologies.
How did you feel about Taylor testifying?
I understood, but I didn't understand, but I respected what Taylor wanted to do.
Now, did you need Taylor at this investor meeting in Los Angeles?
Yes. Taylor was the brains behind our company, and frankly, Taylor had much better ideas than I did.
Did Taylor ever leave the house that night?
Yes. Around 7, Taylor went to a PAD meeting with Casey.
And do you know if Taylor usually drank at these PAD meetings?
Yes. Taylor would often drink at these PAD meetings.
Did you think it was a good idea for Taylor to drink?
This particular night, no.
Now, did you ever leave the house?
Yes. After our argument, I wanted to make things better with Taylor, so I went to a local grocery store to pick up roses and champagne for a romantic gesture of a bath that I was making for Taylor.
And why did you buy champagne?
I bought champagne because I just wanted to share a drink with my spouse after our argument to just smooth things over.
Later that night, were you accompanied by anybody?
Yes, Val and Desi came over and we watched a movie.
And during this movie, do you know if Desi was ever contacted by Taylor?
Yes, I believe so. Desi got a text, but it was during a really intense scene, so I didn't get to read what it said, unfortunately. But I believe Desi was contacted by Taylor.
Later that night, did you ever hear Taylor come home?
Yes, I did. I was actually waiting for Taylor to come home to make sure that the bath was the perfect temperature. And I also heard a vase break in the foyer.
And what did you do next?
I didn't do anything at first, but then it occurred to me that Taylor might be drunk, so I wanted to go check in and make sure everything was okay after I heard Taylor go into the bathroom.
And when you went into the bathroom, what did you see?
I saw Taylor still wearing their clothes that they had worn at the PAD meeting, and they seemed angry.
Did Taylor say anything?
Yes, Taylor told me to get out and broke a champagne bottle.
What did you do next?
Against my better judgment, I left the bathroom just wanting to respect Taylor's wishes. Taylor didn't seem like Taylor was going to get into the bath, so I felt comfortable leaving.
Did you think Taylor was going to continue to drink?
No, the champagne bottle had broke. There was no more alcohol for Taylor to consume, so I left.
Now, how did the next morning start?
I woke up around 7:30 to Desi in my room, and Desi told me that Taylor was dead.
What did you do?
I went into the bathroom to just see if what Desi was saying was true, and that's when I saw Taylor.
How did you feel?
I was shocked. I mean, Taylor had seemed fine the night before, and it just didn't seem real.
Now, later that day, were you ever interviewed?
Yes, I was interviewed by Detective Eisenberg.
And during this interview, did the detective ask you for anything?
Yes, the detective asked me for my keys. I looked in the usual spot. I just wasn't in my right state of mind, and I just couldn't find them. But luckily, my cousin was able to give them to the detective.
Do you know if the detective used these keys?
Yes, the detective did use these keys to look inside my car.
And did the detective find anything?
Yes, they found one of Michael's prized putters.
And why was this putter in your car?
It'd been in my car for a few days. I was planning on putting it in a shadow box as a gift for Taylor because I knew it would mean a lot to Taylor to have a memorial of Michael in the house.
Did you clean this golf club?
Yes, I used a cleaner that had bleach in it to just clean off the golf club.
Now, did you kill Taylor Matsumoto?
Taylor was my spouse, the love of my life. I did not kill Taylor.
Thank you, Ms. Matsumoto. Thank you, Your Honor. No further questions.
Okay, cross-examination?
Yes, Your Honor. Let's talk about Taylor, Miss Matsumoto. You two, your marriage was on the rocks, right?
Yes, but we still had a lot of love for each other.
Well, the two of you had been arguing for months, correct?
We had had arguments, but we never went to bed angry. We always resolved them.
Is that a yes, that you had been arguing for months?
We had had arguments over the past couple months, yes.
You two moved into separate bedrooms.
I just moved into another bedroom to give Taylor space to cope after Michael's death.
Is that a yes, that you two were sleeping in separate bedrooms?
Yes, just to give Taylor space.
And you didn't agree with Taylor's involvement in an organization called PAC, correct?
I didn't agree, but I respected that it was helping Taylor cope with Michael's death.
You two argued about this on June 7th of 2019, correct?
Yeah, we did.
You didn't want Taylor to go testify on Capitol Hill?
I didn't want to, but I respected Taylor's decision.
Now, during this argument, Taylor threatened divorce.
Yes, but we both said things out of anger that we didn't really mean.
Is it true that Taylor threatened to divorce you?
Objection, hearsay.
Your Honor, this goes to the effect on the listener.
I'm going to overrule it. Go ahead.
Taylor threatened to divorce you.
Yes, but again, we both said things out of anger that we didn't really mean.
Then Taylor told you they blamed you for the death of your son.
Objection, hearsay.
This goes to the effect on the listener, Your Honor.
So not for the truth of the matter?
Yes, Your Honor.
I'll allow it for that limited purpose again.
Thank you.
Taylor told you they blamed you for the death of your son.
Yes, and I blame myself too. I left the scooter unlocked.
Well, you were hurt when Taylor said this, right?
Yes.
Now, you talked a bit about Michael on direct examination. You said that you were going to use his golf club as a memorial for Michael?
Yes.
Just to be clear, Michael died in January?
Yes, of last year.
You planned this memorial in June?
Yes, I just wanted time for Taylor to cope, so...
Directing you back to my question, you didn't plan it until June?
I just wanted to give Taylor time to...
Objection, non-responsive.
Sustained.
Move to strike.
I think the answer's in now.
Now, Ms. Matsumoto, you didn't plan this until 3 days before Taylor died, right?
No, the golf club had already been in my car for a few days, so it was before that.
Well, you only put that golf club in your car a few days before Taylor died, yes or no?
Yes.
And you wiped this golf club down with bleach?
Yes, I used a cleaner that had bleach in it.
Please refer to Exhibit C in the binder in front of you. You recognize this?
Yes, I do.
This is a script you wrote.
Yes.
Now, in the script, there is a bathtub prepared, right?
Yes.
You prepared a bath for Taylor on the night of June 7th?
Yes, I did.
In that bath, there's rose petals?
Yes.
You prepared rose petals for the bath for Taylor that night, right?
I did, but this is also just a fictional script.
On this script, there's champagne, correct?
Yes.
Now, you talked about the champagne you got for Taylor on direct examination. You said you wanted to share a drink with your spouse, is that right?
Yes, just to smooth things over.
But when you set up the bathroom, you only brought one glass in, right?
Yes.
Now, just to be clear, earlier that night, you told Taylor you didn't want them drinking.
Yes, because I wanted to make sure that they were ready for whatever was coming in the next few days.
But then you bought them champagne, correct?
Yes, but I had believed that Taylor wasn't going to drink at this PAD meeting, so having a little bit of champagne wasn't going to hurt.
Now, you were aware at this time that being drunk in the bathtub is dangerous, right?
Yes, and that's why I went in to check in on Taylor.
Ms. Matsumoto, I want to direct your attention back to that script. It says that a murder can be made to look like an accident, right?
Not directly, but yes.
You wrote that?
Yes, I wrote this script.
Nothing further.
Any redirect?
Briefly, Your Honor. Ms. Matsumoto, when did you write this script?
I wrote this script about 10 years ago.
And have you recently reviewed this script?
No.
Now, why did you buy a bottle of champagne?
I bought the bottle of champagne because we had gotten in an argument. I hated seeing Taylor angry with me, and I wanted to make things better and share a drink.
Thank you, Ms. Matsumoto. Thank you, Your Honor. No further questions. May this witness step down?
Yes.
Thank you, Your Honor.
Next witness for the defense?
The defense calls Quinn Clampett to the witness stand.
Calling Quinn Clampett. Please raise your right hands. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. Please state your full name, spelling your last for the record.
Quinn Clampett, C-L-A-M-P-I-T-T.
Thank you.
Good afternoon, Ms. Clampett.
Good afternoon.
Where do you work?
I work at Bailey Matsumoto's residence. She's such a sweet girl. She reminds me of my little niece.
And how long have you been working there?
Around 27 years now. 25 years with her grandfather and two years with her.
And how often do you go to the Matsumoto residence?
Every other day of the week.
And Ms. Clampett, which areas are you responsible for cleaning?
Usually the floors, the bathrooms, the bedrooms, just the whole house in general.
And have you ever cleaned the master bathroom?
Yes, I definitely have.
Could you please describe the master bathroom?
It has a very large ground level tub and a very slippery and dangerous marble floor.
And how did you know that the floor was very slippery and dangerous?
I have slipped there once while mopping the floor and sprained my ankle, which was horrifying because I could have gone seriously injured.
And did you know Taylor Matsumoto?
Yes, I did.
And did you know Michael Matsumoto?
Yes.
What, if anything, happened to Michael a few months prior?
Around last year, Michael died in a very tragic accident.
And Ms. Clampett, did you at all observe Taylor's behaviors change after Michael passed away?
Yes, whenever I would go to Bailey Matsumoto's residence, I would notice Taylor drinking, often as early as 1 p.m. in the afternoon.
No objection, Your Honor. Relevance is to Taylor's drinking habits in January of 2019.
Any response?
Your Honor, this shows that Taylor has a habit that has formed over time, showing that she does often drink alcohol.
May I respond?
Yes.
In that case, I change my objection to inadmissible character evidence. May I be heard?
Yes.
It's the prosecution's contention that now the defense is using this evidence to prove conduct in conformity. In other words, because Taylor started drinking in the morning in January of 2019, she's going to do the exact same thing on June 7th. That is strictly prohibited.
Any response?
Yes, Your Honor, this is simply a habit that Taylor Matsumoto has formed. Whether or not it be recent or not, this habit has continued over time.
I'm going to sustain the objection.
Move to strike the answer given.
Motion to strike is granted. You can continue.
Now, Ms. Clampett, did you observe Taylor's behaviors change at all?
Yes.
Thank you, Your Honor. No further questions at this time.
Thank you. Cross-examination?
Yes, Your Honor. May I proceed? Good afternoon, Ms. Clampett.
Good afternoon.
Now, you mentioned on direct you're the defendant's housekeeper, right?
Yes, I am.
You said that you're there every other day of the week, right?
Yes.
So you're not a live-in housekeeper, right?
No, I am not.
Objection, Your Honor. Relevance?
You're proving that Ms. Clampett wasn't a live-in housekeeper goes to show that she wasn't in the house on June 7th. That's the next question that I'm going to ask.
I think this question is not relevant. You can ask the actual question that you need, so it's
yes,
sustained.
Move to strike if any answer was given.
Sustained.
Thank you.
I'm sorry, the motion to strike is granted. Go ahead.
So, Ms. Clampett, You were not at the defendant's house at any point in time on June 7th of 2019, correct?
No, I was not.
But when you were in the house, like you mentioned on direct examination, sometimes you got a chance to observe the defendant and her spouse interact, right?
Yes.
And as you mentioned, after Taylor's late son Michael passed, the relationship got a little rocky, right?
Yes, I would often see them arguing, usually Taylor yelling or screaming at Bailey.
The couple moved into separate bedrooms, right?
Yes.
They rarely spoke with each other, right?
Yes.
And when they were speaking to each other, like you just mentioned, it was often Taylor yelling at the defendant, right?
Yes, and usually about her failures in the entertainment and now autonomous driving industry.
That's right. Taylor would demean the defendant for her failures in the film industry, right?
Yes.
Taylor, you noticed, was also furious that the defendant would continue her tech startup after Michael had passed away, right?
Yes, I would see Taylor yelling at Bailey about this.
And you believe that yelling put a lot of pressure on the defendant, right?
Yes.
Now, you mentioned that you cleaned generally every single room in the defendant's house on direct examination, right?
Yes.
But there is actually one room that you're not allowed to clean, right?
Yes, there is one room that Bailey told me not to clean.
That's the defendant's office, right?
Yes.
Bailey has instructed you not to go into that office.
Objection, Your Honor, hearsay.
Your response?
Your Honor, this statement isn't being used for the truth of the matter, rather the effect on the listener, given that she doesn't enter the office.
I really don't think that it qualifies under that, so the objection is sustained. Go ahead.
Thank you, Your Honor. Move to strike if any answer is given.
Motion to strike will be granted.
Ms. Clampett, that office is where the defendant keeps her personal belongings, right?
Yes.
Or as you put it, that's where the defendant keeps their precious personal ideas, correct?
Yes, that is correct.
Now, finally, you mentioned that you're the defendant's housekeeper. You've been that housekeeper for 27 years, right?
Yes.
So that's hundreds, maybe even thousands of times that you've cleaned the defendant's master bathroom. Right?
Yes, definitely.
You've slipped on that master bathroom one time, right?
Yes, and I've been very cautious after that.
No further questions.
And redirect?
Briefly, Your Honor.
Yes.
Now, Ms. Clampett, you've worked in this mansion for 27 years. However, have you ever been drunk while you were in the bathroom?
No, I would never drink during work.
Thank you, Your Honor. No further questions. May this witness please be excused?
Yes, you are excused. Thank you. Defense next witness.
Yes, Your Honor. The defense calls Dr. Amari Wolpert to the witness stand.
Calling Dr. Amari Wolpert. Please follow me. Please raise your right hands. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes.
Please be seated. Please state your full name, spelling your last for the record.
Amari Wolpert, Wolpert.
Thank you. Your witness?
Good afternoon, Dr. Wolpert.
Good afternoon.
What is your occupation?
I am the lead forensic pathologist at Southern California Forensic Solutions.
And what are your qualifications for this position?
I received my biology degree from USC in 1990. I went on to receive my master's degree from USC in 1994. I also completed a residency in clinical and anatomic pathology in 1998. I finished my fellowship in forensic pathology in 1999. I also spent 7 years in San Francisco as a medical examiner, and I have examined over 24 cases of drowning.
Did you review Dr. Jackson's report?
Yes, I reviewed Dr. Jackson's report, including the toxicology report and the autopsy report.
And do you agree with Dr. Jackson's findings?
I agree with Dr. Jackson's findings that Taylor Matsumoto died due to drowning. However, I do not believe the death was a homicide.
And why do you believe this?
Given the intoxication of the individual and the objects found in the master bathtub.
Now, did you review a toxicology report?
Yes, I did.
And what did this toxicology report indicate?
The toxicology report indicated that Taylor Matsumoto had a blood alcohol content of 0.12.
Now, what does this mean?
A blood alcohol content of 0.12 in general will impair an individual's balance, judgment, and reaction time.
Do you know where Taylor Matsumoto died?
Yes, Taylor Matsumoto died in the master bathtub in the master bathroom.
And do you know what this master bathroom looks like?
Yes.
Turning your attention to Exhibit B. Do you recognize this exhibit?
Yes.
What is it?
It's a sketch of the master bathroom given by Detective Eisenberg.
And is this a fair and accurate depiction of the sketch that you reviewed?
Yes.
Now, what is on this sketch?
Your Honor, in the bottom right-hand corner of the exhibit, there are dimensions given for the bathtub and the trough within it.
And what are the dimensions of the trough?
The trough has 2 edges, both being 20 inches long and 1 inch wide.
Now, did you review the golf club?
Yes, I did.
Did you review the dimensions of the golf club?
Yes.
And what were those dimensions?
The golf club was 33 inches long and had a face height of 1 inch by 4 inches.
Now, after reviewing the dimensions of the trough, what did you conclude?
I concluded that the trough had dimensions that could correlate to the contusion on the back of Taylor Matsumoto's head.
Now, did you conclude a time of death for Taylor Matsumoto?
Yes, I did.
And what was that time of death?
I concluded that Taylor Matsumoto died after midnight on June 8th.
And how did you come to this conclusion?
I used the rigor mortis, or rigidity, of Taylor Matsumoto's body.
And what is rigor mortis?
Rigor mortis is the stiffening of the skeletal muscles after death.
And when does rigor mortis begin to set in?
Rigor mortis sets in the smaller skeletal muscles 0 to 8 hours after death and completely stiffens in the large skeletal muscles 8 to 12 hours after death.
Now, did you review the autopsy report?
Yes.
And did the autopsy report mention anything about rigor mortis?
Yes, the autopsy report indicated that rigor had set in the small skeletal muscles of Taylor Matsumoto's body.
And what did this indicate?
This indicated that Taylor Matsumoto was in the first stages of rigor, that their body had not completely stiffened, and that their body had been deceased for only 0 to 8 hours after death.
And so what did you conclude as the time of death?
I concluded that Taylor Matsumoto died after midnight on June 8th.
Now, in your professional opinion, what was the manner of Taylor Matsumoto's death?
In my professional opinion, an intoxicated Taylor Matsumoto slipped on the wet marble floor of the master bathroom, hitting their head on the trough of the master bathtub, causing them to drown after midnight on June 8th, 2019.
Thank you, Dr. Wolpert. Thank you, Your Honor. No further questions.
Cross-examination?
Before cross-exam, may I have a time check for cross-examination, Your Honor?
Yes. The prosecution has 3 minutes and 30 seconds, and the defense has 1 minute and 49 seconds.
Thank you. May I proceed?
Yes.
Good afternoon, Dr. Wolpert.
Good afternoon.
Now, you spent a lot of time in your report focusing on the fact that Taylor Matsumoto was intoxicated at her time of death, right?
Correct.
And as you mentioned on direct examination, intoxication can impair judgment, right?
Correct.
But, Dr. Wolpert, intoxication doesn't rule out the possibility that Taylor was killed, right?
It does not.
Because Taylor could have been killed whether or not they were drunk, right?
Either way.
Now, I also want to talk about something that you mentioned in your statement. You said that the circumstances surrounding a death are often important in coming to a conclusion about the cause of death, right?
Yes, I said that the circumstances around one's death are more important than the autopsy findings.
That's right. On some occasions, they can be even more important than the findings in the autopsy, right?
Correct.
So let's take a moment to actually talk about some of the circumstances surrounding Taylor's death. You're aware that the defendant and her spouse had a contentious relationship, right?
I was not.
You read the fact situation in today's case, right?
I examined the report given me by Dr. Jackson.
You also read the fact situation in today's case, right?
I know the facts of the case, yes.
So you're aware that the defendant and her spouse had a contentious relationship, right?
Sure.
You're aware that the defendant and her spouse had an argument the night before Taylor died, right?
Yes.
You're aware that the morning after that argument, a golf club was found in the defendant's vehicle, right?
Correct.
No further questions.
Any redirect?
None, Your Honor. May this witness be excused?
Yes. You are excused. Thank you. Defense next witness?
Yes. The defense calls Val Glick to the stand.
Calling Val Glick. Please follow me. Please raise your right hands. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. state your full name, spelling your last for the record.
Val Glick, Glick.
Thank you. Your witness?
Good morning. Good afternoon, Ms. Glick.
Good afternoon.
Do you know Bailey Matsumoto?
Yes, I do.
How do you know Bailey Matsumoto?
Bailey Matsumoto is a very talented producer and also my mentor and a friend.
And have you ever worked with Bailey Matsumoto?
Yes, I have.
And have you ever been to Bailey Matsumoto's mansion?
Yes, it's a very lovely house.
And did you know Taylor Matsumoto?
I did, yes.
Who was Taylor Matsumoto?
Taylor Matsumoto was Bailey's spouse.
And did Bailey ever tell you what they were going to do with the golf club?
Bailey mentioned that she was planning on framing one of Michael's golf clubs in a beautiful display case.
Objection, hearsay.
Any response?
Your Honor, there's an exception for this as to prior consistent statement as well as state of mind to show subsequent action.
Your Honor, as to prior consistent statement, a prior consistent statement can only be offered after a prior inconsistent statement has been offered at trial, and we don't believe a prior inconsistent statement has been offered.
I don't think I've heard one. Anything further?
The state of mind, there's the state of mind as to subsequent action is also an exception.
Your Honor, I believe subsequent action and state of mind are two different.
I don't think that applies here. So, sustained.
Move to strike.
It will be stricken. Next question.
Do you know Desi Kunstler?
Yes, I do.
And do you think Desi Kunstler is an honest person?
Absolutely not, no.
And why is that?
One time I saw Desi take a tip intended for the housekeeper. I do not contend this behavior. It's absolutely repulsive in my eyes.
And did you know Michael Matsumoto?
Yes, I did.
And who was Michael Matsumoto?
Michael Matsumoto was Taylor's son and also the stepson of Bailey.
And did you ever see what kind of relationship Michael and Bailey shared?
Objection, relevance.
Your response?
Your Honor, I'm trying to show that Bailey is a loving and caring person and would not have the heart to kill their family member.
We don't believe the nature of Bailey's relationship with their late son Michael goes to also how they would act with Taylor Matsumoto, considering the two blamed each other for the death after Michael died.
You know, I don't find it irrelevant at this point, so you can go ahead.
Thank you. Do you need me to read it?
Yes, please.
Were you aware of what kind of relationship Bailey and Michael shared?
They were incredibly close. Bailey loved Michael like her own son.
Thank you, Your Honor. No further questions.
Cross-examination?
Yes, Your Honor. Good afternoon, Ms. Glick.
Good afternoon.
I'd like to talk to you about your relationship with the defendant, Bailey Matsumoto. You two are very close, right?
Yes, we're friends.
You believe you're a close friend of Bailey Matsumoto, right?
Yes.
You consider Bailey Matsumoto to be your mentor?
One of my mentors. I do respect her opinion, especially in the entertainment industry.
You also believe that you owe your success in the film industry to the defendant, right?
Part of my success, but also a lot of the work has been of my own.
Is that a yes, that you believe your success, you owe it to the defendant, right?
I owe my initial success to her, as she did discover me on the on screen, but again, my own personal talent as an actor has helped me succeed in the industry.
You believe exactly much of the success that you have is owed to the defendant, right?
Yes, I mean, for just some of the on-screen. I do on stage as well.
Now, I'd like to talk to you specifically about the night of June 7th, 2019. You were with the defendant that night?
Yes.
And you agree that the defendant was acting strange?
Yes, she did seem a little quiet.
And when you asked the defendant why, she told you that she was worried about Taylor's testimony on Capitol Hill, right?
Yes, she mentioned that. She's also very worried for Taylor and going to the PAD meeting.
What she also said is that she was worried about her upcoming meeting with investors, right?
Yes.
Thank you, Your Honor. Nothing further.
Any redirect?
No, Your Honor. May this witness be excused?
Yes, thank you. You are excused. And I think we're at closing arguments. Did we get 4 witnesses? I just want to double check.
Yes, Your Honor. At this time, the defense rests.
Okay, thank you. So we are at closing arguments, and the prosecution, having the burden of proof, goes first.
Before I close, Your Honor, may I retrieve the exhibit binder from the stand?
Yes.
May it please the court? Bailey Matsumoto had a problem. She had invested the entirety of her life savings into an autonomous vehicle company, and now her spouse threatened to destroy it. The couple fought constantly. They moved into separate bedrooms from each other, and then on June 7th of 2019, Taylor Matsumoto informed the defendant of their plans to testify on Capitol Hill in favor of a national moratorium on autonomous vehicles. If Taylor succeeded, the defendant would lose the rest of her life savings. If Taylor succeeded, the defendant would lose the house that she lived in. If Taylor succeeded, the defendant would lose everything. Let's recall the defendant's words on the stand when she was talking about Taylor and what would happen if she testified on Capitol Hill. Taylor had much better ideas than I did. Without her, investors would pull out. So what did she do? She hatched a plan. Murder Taylor to save the company. That night, when Taylor got home from a Parents Against Autonomous Driving meeting, the defendant would bludgeon Taylor with a golf club, leaving them to drown in the bathtub that the defendant drew. Then she'd make it look like an accident. Your Honor, before midnight on June 7th of 2019, Taylor Matsumoto was dead. It all went according to plan. And as a result, the people have charged the defendant with a violation of California Penal Code Section 189. As the people, we didn't just have to prove that the defendant intentionally killed her spouse. We have to prove that she did so with premeditation and deliberation. We had the burden of beyond a reasonable doubt in today's case, and we are confident that we have met that burden. So let's discuss why. The very first witness that you heard from in today's case told you about a possible murder weapon being found in the defendant's vehicle the morning after Taylor Matsumoto was found dead. Detective Casey Eisenberg took the stand and told you about 2 crucial pieces of evidence. First, that golf club that I just mentioned, and second, a movie script found in the defendant's office only minutes after that golf club was found. I want to take those one step at a time, starting with Exhibit D, the golf club. You learned that immediately after Detective Eisenberg found this golf club, she detected the smell of bleach. After doing that, she turned it over to the people's expert, Dr. Jules Jackson, who concluded that the dimensions of this golf club closely matched the dimensions of the contusion on the back of Taylor's head. So, Your Honor, what did the defense tell you about this exhibit? They told you it was a keepsake, something in order to memorialize Taylor's late son, Michael. But let's take a look at the timeline of this golf club per se. You'll learn that Michael Matsumoto died in January of 2019. The defendant didn't do anything with this golf club in January of 2019. Didn't do anything in February. Nothing in March, nothing in April or May either. Instead, she coincidentally has something to do with this golf club when her spouse is found dead in a bathtub. As for Exhibit C, Your Honor, you learned that this exhibit shows plain and simple premeditation on behalf of the defendant herself. Because you learned that a lot of the things that happen in this movie script, coincidentally, happen in their master bathroom on the night of June 7th. You learned that in this movie script, the victim was drowned in a rose petal bath. You learned that it's the exact same thing in today's case. You learned that in this movie script, the murder was made to look like an accident. Your Honor, it is the exact same thing in this case at bar. After Detective Eisenberg took the stand, you heard from Casey Silber about the nature of the defendant's relationship. Miss Silber worked closely with Taylor and was a friend of Taylor before they died. Miss Silber told you on the stand today that on one occasion the defendant approached her and told her she only married Taylor Matsumoto for the money and the success of the startup. Your Honor, motive has been established in today's case. But no one in this room had a better perspective on the events of the night of June 7th than Desi Kunstler. Ms. Kunstler took the stand and told you she was the only other person in the Matsumoto mansion on the night of June 7th besides the defendant and Taylor Matsumoto. And at around 11:20 p.m., which is Taylor Matsumoto's estimated time of death, she heard the sound of something breaking. Let's recall what she did after she heard that sound. She asked if everything was okay. The defendant's response? We're okay. We're going back to bed. Your Honor, you learned earlier in today's trial the defendant hadn't slept in the same bedroom with Taylor in months. Your Honor, we've proven that it all went according to plan for the defendant. And as a result, we ask that you find her guilty as charged. Thank you.
Thank you. Argument by the defense?
Yes, Your Honor. Bailey, Taylor, and their son Michael were a happy and loving family with a bright future. Until tragedy struck. First, a tragic accident killed Michael Matsumoto. Then, consumed by grief over the loss of her son, Bailey Matsumoto experienced yet another tragedy when the love of her life had too much to drink and slipped in the bathroom where they drowned to death. Now the question is, will a third tragedy consume the Matsumoto family? By convicting Bailey of a crime she didn't commit over a death that was a tragic accident. On the night of June 7th, Taylor Matsumoto came home from a PAD meeting heavily intoxicated, as was common after Michael's death. Then Desi Kunstler led Taylor to the master bathroom, where my client had prepared a rose petal bath as a romantic gesture. But when Bailey got to the bathroom, Taylor Matsumoto began screaming and yelling at her to get out. Taylor, drunk and clumsy, knocked over the champagne bottle, causing a loud crash. Respecting her spouse's wishes, Bailey Matsumoto left the bathroom. But my client did not kill Taylor Matsumoto. Later that night, Taylor Matsumoto slipped on the wet marble floor, fell backwards, and hit the back of their head on the trough of the bathtub, knocking them unconscious and leading to their tragic death. A tragedy, but not murder, Your Honor. Now today we heard from Detective Eisenberg, who testified that the master bathroom had a ground level bathtub and a marble floor. We also heard today from the Matsumoto's housekeeper, Quinn Clampin, just how treacherous that floor was. Quinn Clampin herself slipped on the same marble floor and twisted her ankle. We also heard today from Casey Silver, a known PAD member who disliked my client and her company, who testified that on the night of Taylor's death, they were quite clearly drunk. But that's not what she told detectives. Casey Silver misled detectives by claiming that Taylor was just a little tipsy that night. Maybe this explains why the detective jumped to the conclusion of murder rather than reviewing all the evidence in today's case. Maybe this explains why the detective failed to bring the dimensions of the trough, which she measured herself, to the attention of the medical examiner, Dr. Jules Jackson, who assumes that the golf club was the cause of the contusion, even though there is no forensic link. Even though Bailey Matsumoto had testified that that golf club was to be used as a memorial to Michael. even though Dr. Jackson herself testified that it is very difficult to match blunt force objects to contusions. Now, on the night of Taylor's death, they were more than just a little tipsy, Your Honor. Multiple witnesses have testified that Taylor Matsumoto was heavily intoxicated on the night of their death. A toxicology report later stated that Taylor Matsumoto had a blood alcohol content of 0.12. Now, both experts agreed that this would cause impairment. So, Dr. Wolpert, who doesn't just examine a single object, but rather reviews all the evidence and facts in today's case, can come to a compelling conclusion about the manner of Taylor Matsumoto's death. Taylor, drunk, distraught, and alone, paired with a slippery wet floor, slipped, fell backwards, hit the back of their head on the trough, and drowned. Now, it's the prosecution's theory that Desi Kunstler heard this murder take place because she heard a loud sound coming from the master bathroom. But a single loud sound, Your Honor? It's not contended that the champagne bottle broke that night. That is the sound that Desi heard. If Taylor were to knock over this champagne bottle, as the prosecution says, because they were being murdered, why didn't Desi hear the sound of the golf club hitting Taylor's head? Why didn't Desi hear the sound of Taylor Matsumoto crying out? Because Taylor Matsumoto wasn't hit on the head. Because Taylor Matsumoto wasn't murdered, Your Honor. Now, it's the prosecution's theory that Bailey Matsumoto was so meticulous, cold, and calculating that she planned this murder down to the very detail. But as opposing counsel has agreed, without Taylor's ideas, the startup would fail. Taylor being dead was the worst that could happen to Bailey Matsumoto's company. Now, the people have the burden of proof in today's case to prove beyond a reasonable doubt that Bailey Matsumoto killed Taylor Matsumoto with willful deliberation and malice aforethought. And they have failed. Your Honor, do not compound this tragedy with another. Taylor Matsumoto died an accidental death, and we ask that you find Bailey Matsumoto not guilty. Thank you.
Thank you.
Rebuttal from the people, Your Honor?
Yes.
Throughout today's entire case, opposing counsel told you that tragedy struck. They told you that Taylor Matsumoto's death is a plain and simple accident. But Your Honor, if what happened on the night of June 7th was a plain and simple accident, we wouldn't have evidence of a possible murder weapon being found in the defendant's vehicle the morning after Taylor Matsumoto was found dead. We wouldn't have evidence of bitter arguments between the defendant and her spouse on the night of June 7th. We wouldn't have evidence of direct threats being muttered by the defendant after those exact same arguments. Let's recall the words of Desi Kunstler on the stand about what she heard the defendant say minutes after an argument on the afternoon of June 7th. Wouldn't it be a shame if Taylor didn't make it to that Capitol Hill hearing? Your Honor, what happened in that master bathroom on the night of June 7th didn't come from a bottle of champagne and a drunk Taylor. It came from anger and jealousy of the defendant. We ask to find her guilty.
And final comments?
Yes, Your Honor. Now, opposing counsel claims that it isn't reasonable for Bailey Matsumoto to make a memorial to her son several months after their death. It's the prosecution contends that Bailey Matsumoto is just to get over the death of her son only months after it happened, Your Honor. Now, opposing counsel has also agreed that without Taylor's great ideas, as she is the brains behind the operation, the startup would fail. So Why would Bailey Matsumoto kill Taylor if that meant that her autonomous business would fail? Your Honor, the prosecution's theory is convenience, not evidence. And we ask you to find the only reasonable verdict in today's case, not guilty. Thank you.
Thank you. Before I rule on the trial, students may confer with their teachers and coaches regarding any trial irregularities. Would any of you like to do that?
No irregularities, Your Honor.
None from the defense.
Okay. So, this is a bench trial, which means that I get to determine Ms. Matsumoto's guilt or innocence in this matter. We're all familiar with the standard of proof. The prosecution must prove the defendant guilty beyond a reasonable doubt and prove all of the elements to that standard. Based on the evidence and the facts of this particular case, not based on the performance of any of the participants, I will find the defendant not guilty. Okay, now everyone gets to cry and hug each other. Okay. So I'm going to ask the scorers to complete their materials, and while they're doing that, I am going to make a few comments. Congratulations. You all have done an amazing job. From the way you look, the way you present yourself, giving up a Saturday, as well as all of the other days and hours that I've talked about before this, but you all have so much to be proud of. The witnesses, the attorneys, everyone who has presented here today has done an excellent job. I have challenged the attorneys during the pretrial, and their ability to come right back and pick up where they left off, nothing short of remarkable. As I say, you all have so much to be proud of. The attorneys who have been questioning the witnesses, both on direct and cross-examination, you've done a great job. You clearly are very prepared, know what this case is about, know what you have to prove. And as I have said before, when I have had the honor of presiding over these, you all would be welcome in my courtroom any day. The way you present yourselves and the way you present the evidence and are able to command the courtroom is nothing short of, you're ahead of, I'm sorry to say this, probably a lot of people that appear in court on a daily basis. And I won't put a number to that. And as I say, all of the individuals who have participated as witnesses here, I would imagine you are all doing different acting things in your life at school because you all have done a great job. So I know that you all have great futures in whatever you do. You've been able to accomplish something, whether you love the courtroom or the law or not. You are all excellent at what you're doing here. So again, thank you. I'm quite honored to be here.